Emily, see if you can change your name.
Why am I Kristen?
I don't understand. I don't understand why you're me, but
I didn't even see that.
I know you
I
don't
think
want to
I
be,
used
so
your link. Maybe it's because I used your link.
maybe
How's that?
that's accurate.
Yeah.
Hi, Emily. Hi, Renee.
Hi, how are you?
Doing fine. How about you?
I'm excited to talk about service animals today.
All right.
We
Well,
have
it's 12:01. I think we'll go ahead and get started. Welcome, everyone. This is the Special Education Legal Clinic for November. And today's topic is hot topics in special education. So we're going to go around the room and everyone will have about 10 minutes to present a hot topic in special education. Before we get too far into it, I'll start with the series. As you probably know, to register for any of the workshops, you can go to lawyersforstudents.com/legal clinic. That's where information and registration exists. It also has this whole series of workshops. We are 2 workshops into the series, and this goes through next August. So we have a long series, and we call it the Advancing Advocacy Series. And today, like I mentioned, is Hot Topics in Special Education. We continue next month in December with Family Engagement in Special Education. And this is from the Ohio Statewide Family Engagement Center. And we'll have a guest speaker for that one. A couple other things that exist at the page. There's a resource page, a parent resource page, which with lots of resources that the collaborators have put together. That includes Abdenor-Weicker, Disability Rights Ohio, and the Ohio Coalition for the Education of Children with Disabilities, resources that are available for parents. Okay, like I mentioned, today is Hot Topics in Special Education, and I'll start off actually with our first topic. And if we have enough time when we get to the end, we will open it up for questions for the panelists here. We'll see how it goes. We have a lot to get through, but we'll try to do that before 1 o'clock. And again, if we have time, we'll take some questions. So if you do have questions, please drop them in the Q&A box. And some of the other panelists who aren't speaking at the time will try to answer those. Or if they need to, they'll stop me and ask me the question, or I can try to answer some questions right at the end of my component. Again, we each have about 10 minutes or so where we're going to present on a topic. If we can save the question till the end, we will. Otherwise, for any of the other panelists, feel free to interrupt if we think it's appropriate. Okay. First hot topic is school staffing shortages, and I'm going to present this one. If you work in special education at all, or if you have a child with a disability, you may have seen this come up. It's certainly a hot topic nationwide. And if you wondered, there is a shortage. It's not just in Ohio, it is a nationwide shortage. And it said more than half of school districts nationwide in this past school year, and 80% of states reported a shortage among special education professionals. And it's you'll see here about 46,000 special education teachers leave public schools every year, and all of the teacher preparation programs combined are really training fewer than 30,000 new ones. So you see, it's just really a supply problem. But surprisingly, the number of people or professionals entering special education has actually risen over the last decade. So supply is actually up, but so is demand. So it's really a demand side problem. So a few things that are helping or contributing to that demand. More private and community schools are hiring special education teachers and aides in order to provide services to students with disabilities. That's a more recent phenomenon. Of course, we've gotten better over the years at evaluating students and identifying students with disabilities. So just from that perspective, the numbers have gone up. In Ohio specifically, the availability of alternatives to public schools, including the John Peterson Scholarship and the Autism Scholarship, have allowed more to transition to private schools. So that drives a little bit of the need, or a lot of the need in Ohio, for private schools to hire special education professionals. And it also, of course, drives the demand for those professionals. And surprisingly, the percentages of special education teachers entering the workforce has actually outpaced regular education teachers entering the workforce. So more, and you may have seen too, this of course is not just a parent problem, it's the school side problem. So, you know, the Department of Education, both the Ohio Department and the US Department of Education, have comprehensive programs to help train and recruit special education professionals. Some states, not quite yet in Ohio, but some states have identified alternative licensing programs that make it easier for special education professionals to join the profession. In Ohio, of course, you need a bachelor's degree to be a special education teacher. And then you have to be licensed by the State Department of Education to be a teacher, a paraprofessional, an aide, on down the line. So there is a trend nationwide to reduce that. Indiana's got a program. It's kind of an alternative pathway for special education professionals. So it's being addressed on and lots of different levels. But what we want to focus on mostly is that you know, what parents can do about it, or what professionals who are dealing directly with these staffing shortages can do to help parents and children with disabilities. I mentioned at the bottom here, the demand has risen. And here are just a couple things to look at in terms of demand. These are just numbers of students enrollment in special education over the years from 2016 to 2023. You see the numbers have gone up for all the reasons that I mentioned already. One big contributing factor is that vouchers are more and more available and being used more often by families who have a child with a disability. And of course, those vouchers mean that those students are either attending attending private schools, or in some cases, getting their services outside the school district. And I didn't put numbers in here about Ed Choice because it's not a special education specific program or scholarship, but it has caused quite an increase in students attending private schools, because of course Ed Choice, with the expansion last year, has given about $8,000 for high school students per year to attend a private school. And although those students may not be identified with a disability, it is causing enrollment to surge in private schools in Ohio, and causing private schools to hire more and more professionals in the area of special education. So you can see how the demand would increase for these types of professionals, even outside of public education. Oops, I have skipped one. Yeah. Of course, we're not just talking about special education teachers. We are talking about bus drivers and nurses and paraprofessionals, aides and assistants, and we're talking about therapists. These are all, of course, professionals who provide services to students with disabilities. And you may have encountered situations where schools just don't have access to the professionals they need to service a student or lots of students with disabilities. I know some of the big urban districts have had real problems just staffing classrooms, but it goes well beyond classrooms. And so it's really a conundrum that exists, again, nationwide, but specifically in Ohio. I think the rates are a little bit higher in Ohio for the shortages than they are in other places. But of course, all of these things, if these are services or related services being provided on the student's IEP, it causes a real challenge for school districts, and of course for the child with a disability if they don't have access to the service. And sometimes it means the child can't attend school. You know, it was very prevalent during COVID, and as we came out of COVID, for students, if they didn't have access to a particular professional, then it wasn't safe for them to go to school. In a lot of cases, they didn't. And now they had what they identified as recovery services back during COVID, where, if you didn't have access or the ability to attend school because of a staffing shortage, you could try to recover those services from the school district at the end, which is very similar to compensatory education, which we'll talk about here in a few minutes. But it does make it a real challenge when you don't have access to the school environment, number one, or if you have access and just don't have access to a professional that you need to service the IEP. Just to be clear, students are still entitled to a FAPE, and this is individualized special education and related services designed to meet the child's unique needs. That doesn't go away because the school district doesn't have access to a professional to provide those services. In a lot of cases, it's not even a resources problem. It's just access to professionals or the onboarding or HR process, which becomes a challenge for school districts to get, let's say, a one-to-one aide that they might need or a therapist that they may need. So if those services aren't provided to a student, of course, that's a violation of FAPE, and students would be entitled to compensatory education if they have not received a FAPE. Now, there are a couple of things we'll talk about that you can do to try to preserve that compensatory education. Again, during COVID time, it was called recovery services, but the child still would be entitled to comp ed. And my advice would be to be somewhat sympathetic to the school district's situation. It is just a nationwide problem, and be collaborative to the extent that you can and helpful, but be sure to document the issue and reserve your rights to the special education and related services, which again, we'll talk about in the next couple slides here. So being collaborative, so help the school look for alternatives. So, look for, because there is this prevalence specifically in Ohio of other providers or service providers for the John Peterson Scholarship or the Autism Scholarship. Sometimes these are private schools, sometimes they're just service providers who provide these related services. Look for a provider who might be able to provide these services either in or outside of the school environment, and see if they can do it on-site or outside. And if they do have the service available to come to you or for you to take your child, offer that to the school district as a way to provide services in the meantime at district expense. Because again, this really shouldn't be a resources problem. Sometimes you have both, of course, but it doesn't matter. If there's an alternative that you can identify to get the IEP serviced, and then you can offer that to the district. You probably are more resourceful or can be more resourceful than the district will be, because they're used to working with their particular contractors or their employees specifically. But it is always an option to amend the IEP or to have kind of a temporary agreement to provide services in the meantime, so you don't fall behind. Because even if you have a right to file a complaint and recover those services later, if you can avoid falling behind, of course, that's much better than trying to recoup the services later. So make a proposal to the district, be creative, document the deficiency. Of course, this is important in a prior written notice. If they're just telling you, I'm sorry, we can't provide the aid, we just don't, we need to onboard somebody. And by the way, onboarding takes months typically. It's not a fast process. Look for a contractor, look for a service provider. If that doesn't work, you have to document the deficiency with, of course, the dates that the service should have been provided, and make sure that that's documented, that they identify that they are supposed to be. And then, although you're being collaborative here, it's not a step too far to tell the district, hey, look, you have 1 year to file a state complaint. If services are not being provided that are supposed to be provided, you should communicate to the district or the special education director or coordinator that you're going to have to file a state complaint to preserve the access to those services until or unless those services come. So I don't think it's being too contentious to, work with the district to do that, to try to find an alternative. But if that doesn't work, you might have to do it. The alternative to filing a complaint is if the district would enter into an agreement that they will provide the services. They haven't, again, for a period of time. This is beyond just documenting it on the IEP on a prior written notice. If they enter into some type of agreement where you both sign and it's approved that you're going to be entitled to compensatory education for all the time that you missed, then that's one alternative to a state complaint. But I'd be very cautious about that unless the agreement is, signed by both parties and approved by the Board of Education, because if you miss your deadline, now if it's a continuing violation on a state complaint, meaning that the services are continually being withdrawn or withheld because they don't have access to the professional, then you're not so concerned about the statute of limitations on a state complaint. However, you can't go beyond 1 year back in time. So, once you get close to the 1 year mark and the services have been withheld or not provided, you probably want to seriously consider filing a state complaint if the Board of Education won't enter into an agreement to take ownership of the deficiency. And then here's what you would allege. A state complaint, for those of you who haven't done this in the past, it's just a written complaint. It can be by a parent without a professional, and it just identifies, the violation of IDEA. So it can be pretty straightforward. There's a template that exists at ODE's website. Here are some of the things that you would put in there. Any one of the 5 identifying the violation of IDEA, which would ultimately be decided on paper after some back and forth and questions and answers that were asked by the education specialist. So that's what you can do. It is really a conundrum, like I mentioned, but and schools are trying to address it. Departments of education are trying to address it. But you absolutely should preserve your rights, and it's not, a bridge too far to say, oh, look, I'm going to preserve my rights by filing a state complaint. All right, that's my part. Any questions? None that have come up yet? Okay. All right, then we'll turn it over to Renee for service animals in schools.
Thank you, Mark. I see Tammy has her hand raised. Tammy Sebastian, hi. I see you have your hand raised. I don't think there's any way we can hear you, even if you were to like unmute yourself or anything, since it's a webinar. So if you have a question, just drop it in the Q&A and we're happy to answer in the chat. Same with Laura. I see you raised your hand as well. If you have a question, just feel free to drop it in the chat and we can respond at the end of each of our little sessions or at the end of the greater larger S session. So anyways, yes, service animals in schools. Mark, you can go ahead to the next slide. Or am I clicking? Okay. Yeah, okay, you got it. Thank you. So what is a service animal? I have a couple slides kind of going into the definition of a service animal, because I know that there are a lot of different types of assistance animals out there these days. But the definition under Title II of the Americans with Disabilities Act, the ADA, says that a service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. And the work or tasks performed by a service animal must be directly related to the individual's disability. So what does all that really mean? Mark, you can go to the next slide. Kind of picking that apart, of course, you kind of heard me emphasize that word dog. Yes, under the Americans with Disabilities Act, a service animal must be a dog. Again, I know we have emotional support. Bunny rabbits are kind of emotional support lizards. They're kind of crazy things we've seen in the news, things like that, but those are not considered service animals that are protected under the laws of the Americans with Disabilities Act. Specifically, it says, again, and I pulled a quote in there from the ADA that says other species of animal, whether or not they're trained or domestic, they are not service animals under the ADA. And again, that last emphasis I put in was that the animal must perform work or tasks that are directly related to that individual's disability. So there's a long list of examples. I'll kind of run through them a little bit because they are important examples that can be utilized in the school environment by students with disabilities. So specific tasks laid out under the ADA, and of course it says including but not limited to, so these are not all the tasks that they can perform, but assisting individuals with visual impairments to help with navigation, assistance with individuals with hearing loss, or individuals who are deaf with presence of people or sounds, providing nonviolent protection or rescue work, pulling a wheelchair, assisting an individual with a seizure, alerting to allergens, retrieving items such as medicine or a telephone or other objects, providing physical support or balance, and helping people with psychiatric or neurological disabilities by preventing or interrupting any disruptive or impulsive behaviors. And again, the ADA does specify, and it's that last quote down there, that the provision of emotional support or comfort or companionship of an animal does not constitute work or tasks under this definition. So that essentially is excluding emotional support animals. It must be directly related to that. They must be able to perform a specific task related to that individual's disability. Next slide, please. So just to kind of help separate that out a little bit, I think it's probably hard to read, but this is one of my favorite Venn diagrams. I tried making my own, but I can't figure out the technology to do it. But essentially a service dog, what we're talking about here today, it has its own definition in that blue circle. It's a dog that assists an individual with disabilities. They have that specific training to perform a task to assist with that disability, and they have those protections under the ADA. And would be allowed in public places like a school. Then you can kind of see that overlap with a therapy dog, which is the one I have napping here next to me. A therapy dog is different. They do not have protections under the ADA. It is a dog that has specific training, but it is to bring comfort to other people. It's to comfort other people rather than to specifically aid the person who is handling the therapy dog. And then the emotional support animal, again, this one is a prescribed animal for a person. It says mentally disabled. I don't really like that terminology, but for a person with a mental health disability, but they don't have that special training requirement, and they don't have any specific tasks or work that they're required to perform. So they don't have that protection under the ADA. Next slide. So like I've been talking about, we've got 3 different civil rights laws essentially that protect students with disabilities rights in schools, and that essentially allow for the access of service animals in schools. The first being the one that I've been naming, Title II of the ADA. Title II of the ADA, essentially, it's a pretty broad anti-discrimination law. It prohibits discrimination based on disability in all services that are provided by state and local governments, which includes public schools. So that requires, Title II requires these public entities, schools, to make reasonable accommodations to avoid disability discrimination and be able to provide accessible services and facilities for people with disabilities. Similarly, Section 504 prohibits discrimination based on disability, but it's instead of for state and local governments, it's for programs that receive federal financial assistance. Again, this is still public schools that we're talking about here. But really Section 504 ensures that students with disabilities have equal access to education by requiring schools to provide reasonable accommodations similar to Title II. And then again, of course, we have the Individuals with Disabilities Education Act, the IDEA. This is what requires I think Mark had mentioned this, that our children with disabilities receive a FAPE from their public schools, and through the public schools provision of a FAPE to the student, it requires them to provide students with disabilities with specially designed instruction and accommodations to ensure their access to education. So, Mark, go ahead, next slide. all of that being said, with all of that legal framework, do students have the right to a service dog as an accommodation in the public school setting? Next slide. Yes, they definitely do. Next slide. As you can probably tell from my explanation of the legal framework under the ADA section 504 and the IDEA, if your child qualifies, and if your child qualifies for an IEP under the IDEA. Public schools do have a duty to provide reasonable accommodations to students to allow access to their services and programs. Under the ADA in section 504, this is unless the presence of a service animal would require the public school to fundamentally alter their services or programs. But for a service animal, this is a really high burden to meet. So usually it doesn't find it as fundamentally altering their service or programs. Again, you can also argue under the IDEA that the service animal in that case, again, it's based on the students, but perhaps it is required for the student to receive a FAPE to have a service animal as well. If that's not the case, though, again, under the ADA in section 4, they are required to allow reasonable accommodations for students. So Mark, next slide. That being said, some of the roles of service animals in school, something Mark had mentioned, with the staff shortages going on, service animals can perform a lot of tasks that perhaps a one-on-one aide could perform, or even assistance with balance and stability, like help that an OT would help with. So, again, not that service animals are easy to come by either, but just another helpful solution to the staff shortages would be service animals in schools. But just a couple, again, there's so many different ways that service animals can aid in schools, but just 3 general ways that I had thought of were promoting student independence through guiding students with visual impairments or assisting students with physical disabilities throughout the school or with academic tasks. Supporting student safety for students with medical conditions or allergies by alerting for timely intervention, diabetes, seizures, lots of different support or lots of different support tasks for that. And then there's also service animals who can provide a calming support. Of course, it has to be a specific task, perhaps deep pressure therapy, or alerting a student to go into a safe position, but providing that calming support for a student with a mental health disability to allow for that student to be able to stay in maybe the gen ed classroom longer, be able to engage with their peers more. Next slide, Mark. And then of course the responsibilities of the student and family. Under the ADA, a public school, of course, can ask an individual, well, a public school or really any public entity can ask an individual with a disability to remove the service animal if the service animal is out of control, is not housebroken, or poses a direct threat. All very reasonable, of course. And so that being said, students and families should make sure that their service animal is properly trained and maintained in good health. Make sure they communicate the specific needs of the service animal to the school. So if there's any requirements that maybe for a dog to open a door, maybe they need some rope on a handle or something to help with opening the door, or the dog needs to go to the bathroom at a certain time of the day, just making sure to communicate those things with the school, and of course maintaining documentation of the certification just in any case. And then next slide should be my last slide. Just kind of best practices for public schools. There's not really any state law or state federal law anywhere out there requiring that public schools have policies for service animals, but they really should, especially if they anticipate a student coming in with a service animal. They really should have those clear and detailed school and district-wide service animal policies, and make sure their employees are aware of the rights of students and animals and have guidance on how to interact with them. Of course, you may have some conflicts that come up. There may be other students who have allergies, or other even employees who might have phobias. But of course, at that point, the student still does not negate the student's right to have a service animal in school, right? The school should really, and I mean, parents, of course, can start working with this, can kind of encourage the school to kind of do these things, but working with the affected students and their families to adjust seating, classroom arrangements, schedule arrangements, just to make everybody comfortable. Using separate entrances is on there, but of course not making the person with a disability use a separate entrance based on their disability. And of course, just making sure that the school is understanding that above all else, the student has the right to the service animal. And of course, having a plan for conflicts in place. If, again, schools aren't required to do this, but it should, in their policy, having something laid out that says, if there's a conflict between students and staff and the other animal, how that's going to be carried out, how the school will handle it. And of course, if there are any issues with a school providing access to any issues with a school refusing to allow you to bring your service animal to school, you can file a complaint with the U.S. Department of Education. There are many, many complaints through the Office for Civil Rights that have found that a service animal needs to be included in the school environment. So with that, I will hand it off to, I actually don't know who's next. Maybe it's Amy. I see her unmuting. Or
Well,
maybe it's
Renee, there are a couple of questions.
Oh, there's
and
questions. Okay, I can answer questions.
Do you want me to
Yeah.
read them?
Let me see. I'll read. I can see the first
Great.
one. The first question I see is if the child would need a handler for the service animal, how would that be addressed in an IEP? Usually, I think it would just say the handler would just be written into the IEP, but it would probably be noted that this, again, the schools, I actually have seen a decision, I'd have to go back and look at it, that said that if a handler is required for the service dog is required for the student to access, that the school actually would have to provide a handler for the service animal. So that decision would make me think that it could even be included it should be included in the IEP. So I would see that would probably be under support for schools personnel, the support for school personnel section. Perhaps it would just say an aid to support, service dog. It wouldn't say, it usually in there it says, aid support services to assist with student behaviors or something. It would probably just say aid support services to assist with handling of service dog. So I hope that helps answer that question. And then, does the school have to help toilet the dog, or is it the child's responsibility? At that point, I mean, the school has to allow access. If the child is able to handle the dog, if the child is the handler of the dog, the school absolutely has to provide access for the dog to use its facilities outside at some point. And it would be the child's responsibility. However, if the child is not the handler, if there is if the aide is the handler at the school, then it would be the school's responsibility, of course, to take the dog outside, to go there. But yes, the child, if they are the handler, would need to take the dog outside, but the school would need to let them do that. So thank you for the questions. I appreciate it. And Ruth, go ahead.
Thanks, Renee.
Hi, everybody. I'm going to present on school threat assessments. It's obviously a hot topic. It's been a hot topic for about 25 years, I think, for most of us who can remember Columbine. And we'll get right in on what is a threat. The next slide, please, Mark. So what is a threat? Lots of things could be considered threats. It's not necessarily only something spoken from one person to another. We have seen gestures, hand gestures like holding a gun. We have seen memes or the posting of pictures on chats, sometimes Snapchat, sometimes things that have been screenshotted by other students and sent to the school or reported to the school. Just means to say it does not have to be a spoken threat of intent to harm someone. It can be in lots of forms. We have seen threats that get reported by students' parents saying, hey, my kid overheard something at school. Can you investigate it? We have had comments that have been made via email, via phone chats with friends. We recently just had one actually that was picked up by the FBI monitoring system, which I think in a perfect world, we all want that level of detailed oriented assessment happening in the background. In that case, a student in a private text chat to 20 other students made a threat that some algorithm picked it up and reported it to the FBI. None of the 20 recipients of that screenshotted message took it seriously or reported it to the school. But things happen in lots of different formats is what I'm saying. And lots of things can be considered threats, whether or not the person who is on the receiving end of the threat hears it or that message is related to them directly by the person making the threat. So generally speaking, our expectation now is that anything that's not easily recognized as a threat should be reported to school administrators, parents. You know, we all want our kids to take this seriously and report when they hear or see something. It's what happens next, the responsibility on behalf of the school, that is a little bit more of the nuance of how things get handled. So we'll go to the next slide with that. Back in 2021, early part of 2021, the Ohio General Assembly passed the Save Our Students Act. This took 2 years to become effective. And this act essentially requires each school with students grades 6 through 12 to assemble a team, and they propose a multidisciplinary team, teachers, school counselors, school resource officers when schools have them. So we're talking high schools there, but to gather together a team specific to the individual threat. So if a sixth grader makes a threat, we would expect to see some of that sixth graders teachers or people who interact with that sixth grader on the team. But we also want a wider representation, principals, school resource officers, counselors, special ed directors in the case of special ed students, to weigh in on assessing whether or not this is a credible threat that needs some follow-up. The Save Students Act also requires these teams to be trained. They require the training once in the first year that you're assigned to a team, and then once every 3 years thereafter. And there are model protocols online that really help the school teams understand what it is they are looking for. We want those teams to be well-versed in threat assessments, to understand the law, but also to understand how this whole process impacts students and their schools. For a point of particular interest, we have seen in our practice, some schools undertake school threat assessments that require about 2 to 3 hours worth of work on behalf of the school threat assessment team. They're very, very comprehensive. I printed out one here. It involves things like locker searches, library books that they've checked out. I don't even know if kids actually check out physical books anymore, but they go and they look at what books the kids are looking at, and then also search histories on their school internet. They look into students' past police records, if there are any. They're looking at their ELA journals. What are these students writing about? What do the teachers hear? They check with the school counselor, of course. They're checking social media history. They check with the school nurse. Does this student come in? Do they have some complaints? Are there somatic complaints? They take teacher statements, and then they take witness statements. That type of threat assessment will take a school about 2 to 3 hours to undertake. It's very detailed. It's very thoughtful. It follows the model policy and protocol, which is all available on the state's Department of Education website. And those schools, I think, do a much more thorough job who follow this kind of protocol in determining whether or not they are dealing with a situation that needs to be taken seriously. Other schools don't follow that plan. We have seen schools who do a very poor job here in Ohio. We have one, I don't think the team of eight people, 5 teachers, a principal, assistant principal, and the school counselor. I don't think they spent 5 minutes assessing the threat and quickly marked it as a high threat. And we'll get into what those threat classifications mean. So some good jobs and some bad jobs. Schools would be really well placed to start following that kind of standardized protocol and to train their teams accordingly. This slide, I just want to give some thoughts as we look back toward past 25 years and what we do know and don't know about school shooters. We do know that there is no single profile of an attacker at a school. All different grade levels and types of schools have been targeted in the past. Half of those attackers had a history of interest in violent topics. They have access to firearms in the house. But most of these student attackers also had experienced some psychological or behavioral symptoms that the school was aware of leading up to it. Most of them experienced some negative home life factors like housing instability, divorce, death of a parent, lots of school disciplinary action in the past, social stressors, which we would hope would become known to school counselors. The data available, and there is a federal agency that tracks all of these school shootings, and there have been many. They said that every single one of the school attackers have exhibited concerning behaviors which were known to the school and the community prior. Most of the school attackers also have communicated their intent to attack. So that's why these threat assessments are really important. We can go to the next slide. So this is just one classification level that's available. Schools use different ways of measuring the type of threat. You can see in the first case, there doesn't really seem to be a risk of violence or harm. And the school can really treat this once they go through the steps of how can we support this student. Sometimes in the case of younger students, it might just be coming in and setting those expectations with the students. These are not things we say. I'm going to quote Mark here, who did a great presentation for our firm and said, you know, don't do it and don't do it about school. Our kids don't know that joking or playing, you know, my finger gun kid, behavior that we expect to see from very young children sometimes is now essentially outlawed at school. So I think when we think about the school setting right now, and we realize the types of experience our children have, our children are undergoing trainings every year for how they'll respond in the event of a school shooter. We're putting this information into our children's heads, but we're maybe not telling them that even joking or playing about this type of attack is never acceptable at school and will always lead to some intervention on behalf of the school. So again, low, moderate, high, imminent. Sometimes we talk about threats as transient, a student, you know, really upset or really angry about a certain interaction with a person or a staff member will express some negative plans. But if they don't follow through, if there's no intent to follow through, that threat could be deemed as transient and handled with situations and services that the school has, including counseling, meeting with the school resource officer. The higher threat level, of course, is when police are going to be involved. I can't give a percentage, but I'm going to say nearly 100% of our students who are receiving discipline, suspension, or expulsion for making school threats, nearly all of them get reported to the police. And I would say in about 80% of the cases, charges are being filed, and serious charges. We're seeing felony 2s for inducing panic being charged against these students. Sometimes we see charges in the misdemeanors for making false threats. That's when the school deems that it truly was not intended for harm, but they still file court cases on these students. So we go to the next slide, the last slide. Again, conversation is going to be key. Students are most motivated to plan a school attack because of a grievance with staff or their classmates. We want to normalize having conversations. We want to support our students. We want to make mental health a priority at our schools. We want to address bullying. Every school has taken that hard stand against bullying. In lots of these cases, bullying is at the root of these threats that are being made. So we need to normalize having conversations and bringing the parties together to create an environment where students are going to be heard and feel supported. I think we need to also work on building interpersonal skills between our students, and destigmatizing mental health or mental wellness. Bringing those conversations to the forefront will definitely help us in addressing whether or not to take a threat seriously. We also have to teach our kids. We need to talk about it. We need to understand what's acceptable conversation and play at school, because certain things will be taken seriously. And we're hoping that targeted school violence is preventable when we have these early warning signs and schools intervene appropriately. I don't know if I have any questions. It looks like there might be one.
Let's save that to the end for the sake of time,
Okay.
because we only have about 12 minutes now for Kristen and Emily. Thank you, Ruth.
And I will answer in the chat, actually. Okay.
Thank you.
Okay, Mark, next slide. All right, so one of the hot topics that we see in our office all the time is discipline of students with disabilities. And today I'm just going to cover one small aspect of discipline, and that is the issue of serious bodily injury. And it's one of the reasons that a school district can discipline a student with a disability and remove them from their educational environment. It is an exception to the general rule that we've talked about before in these presentations, and that is that students with disabilities can generally only be removed from school for disciplinary reasons for 10 days in a school year. And when they're removed beyond 10 days, special protections go in place. If a student is accused of inflicting serious bodily injury and the district finds that that's true, they can then be removed from their school, their educational placement for up to 45 days to a place that's called an interim alternative educational setting. And that would be different depending on the situation. And that's regardless of whether it's caused by their disability. Serious bodily injury is not defined in IDEA. It is defined in federal criminal law, and I've got the code section there. And it's got a specific definition, and that is if a student inflicts injury that involves a substantial risk of death, extreme physical pain, prolonged disfigurement, or the prolonged loss of or impairment of a bodily function or mental faculty. Next slide. So the only guidance that we have about what has been found to be serious bodily injury in an educational setting is through decisions by hearing officers in court. So I did a review and am going to talk to you about what some hearing officers in courts have determined is and is not serious bodily injury. This Kansas case, a 12-year-old child hit their paraprofessional on the head 4 times with a closed fist, but it was determined not to be serious bodily injury because the injury was very short. The staff went to the hospital, but was not prescribed any kind of pain medication, and actually was back at work very quickly. So that was determined not to be serious bodily injury because of it was not a prolonged injury. Next slide. In this case from Texas, a student with autism also struck a staff person. It was a teacher, but the teacher only missed 1 day of work, and the injury was described as a sprain. And so the district could not, the hearing officer determined it was not a serious bodily injury because that staff person was back at work pretty quickly, and it wasn't described as a serious injury. Next slide. This case out of, whoops. Okay. This case, it was a student on student issue, and one student gave a prescription pill to another student. That student was sort of behaved erratically for one day after ingestion, but didn't get super sick and was back at school. So that, again, was not considered to be serious bodily injury. Next slide. All right, so another case out of Massachusetts. This case was interesting because the hearing officer determined that the student did not inflict a serious bodily injury, even though the injury itself was pretty serious. The educator had 2 broken legs, but the broken legs occurred because the educator was trying to separate 2 students that were fighting, and the student actually never made contact with the staff person. They were injured as a result of breaking up the fight. So the hearing officer said that student didn't inflict the injury because he actually never touched that staff person. All right, next slide. All right, so there's also a series of cases where hearing officers in courts have determined that a student did inflict a serious bodily injury. And in this Pennsylvania case, even though the hearing officer said it was a close call, the school counselor suffered protracted mental impairment. It was a concussion, and what she described as the worst headache of her life. So because it was protracted, the concussion was protracted for this staff person, the hearing officer determined that this was serious bodily injury, and the student was the school could remove the student to another location. Next slide. All right, in this case, the student struck his paraprofessional, and the paraprofessional suffered a severe concussion, including intense headaches, a lot of difficulty focusing, and sort of long-term impaired thought processes. So again, because of the prolonged nature of the effects of this injury, it was determined to be a serious bodily injury. Next slide. All right, I'm gonna, Mark, if you could just go through here, just go ahead and go forward because I want to give Emily some time. And we'll just go back to that one with the color. Yes. All right, so just what the trends say is that these are the following things that hearing officers or courts will consider in determining whether or not the injury was serious bodily injury, the extent of the pain inflicted, if there are significant psychological or cognitive impacts that are long-term from the injury, the extent of medical interventions required, like did the person have to go to the hospital, were there lots of follow-up medical appointments, those kinds of things, and whether the student intended to inflict the injury. And that is the actual infliction aspect of it. Okay, I think it's my last slide. Next. All right, so this is what you can do as a parent if the school is alleging that your child has inflicted serious bodily injury. You want to get all of the facts about the incident. So you want to get all of the incident reports. You want to get any kind of access to medical records or specific descriptions about the incident and the effects on the person who was injured. You want to determine if the infliction of the injury was a result of interference from others. So did the student actually inflict the injury, or did somebody get hurt trying to break up a fight, or was somebody hurt during a restraint event and the student didn't intend to inflict that injury? And then don't assume that the injury meets the definition. This definition is a very high standard, and we have a lot of cases where it just doesn't meet that standard, but the school district is still making that allegation. Okay, Emily.
Thank you so much. I'll just start by saying that a lot of this information is taken from a flow chart that's available on Ohio Department of Education and Workforce's website, which explains it probably more clearly than I can. It's a cute little flow chart. So if you're interested in deferring your diploma, maybe check that out and you can follow through. But I'll get into some details here. So why don't you go ahead, Mark? So what is a deferred diploma? In Ohio, students on IEPs may be eligible to receive school services until their 22nd birthday. Sometimes this is also called extended eligibility. Next slide. If a student on an IEP does not meet Ohio graduation requirements, then they would qualify for extended eligibility. Keep in mind that there are many pathways to graduation these days in Ohio. You can get SEALs for a job, for volunteer work, all sorts of stuff. But if a student does not meet those criteria, they would be eligible for extended eligibility. If a student does meet those graduation standards, then they might still be eligible under the following exceptions. So if the student used their IEP goals to meet curricular requirements, if they took the alternative assessment, or if they were exempted from their end of course assessments, they are qualified to receive services until their 22nd birthday. Next slide. You can also meet graduation using the typical pathway, but you might still not be ready for graduation. In this case, the IEP team should have a discussion about whether or not that student is ready to graduate, and they need to consider the following two factors. Did the student make progress on IEP goals and objectives that adequately addressed identified needs in their educational and functional performance? And did that student receive transition services that reasonably enabled the student to move toward post-secondary goals? Next slide. So how do you defer a diploma? The first step is probably the easiest. You need to discuss it with your IEP team. I've had some families who are like, how do we defer it? And they haven't even talked to the school yet. I would start there. You should be talking about graduation beginning when you start your transition period in your IEP, so age 14. Let the team know you want to defer your diploma, and then make sure that the team is collecting data on what that student's transition needs are and if they're being met. Next slide. This is an important factor to be aware of. School might look really different when you defer a diploma, especially if you've already finished your curricular requirements within your high school. So let's say you've finished all your science credit, you finished all your academic credit. Some parents think that deferring a diploma just means you get another year of school. It might look like that, but typically what's going to happen is the shift is going to change on the focus on the student's services is going to change once they hit that age after high school. So they might be looking at transition programs, career center programs, programming in the community, like volunteering at a job option, or transition programs that specifically help with independent life skills and job skills. Another important thing to be aware of is that school might not be all day while you're deferring a diploma. There's no guarantee that it's going to look exactly how it looked when he was in high school. And that's it.
Well done. We just got it in. So yeah, we do have a hard stop at 1 o'clock because we have the individual guidance sessions that start right at 1 o'clock. So thanks to everyone who presented today. We got through a lot quickly. And if there are any other questions, let me just take a look here. Oh yeah. Thank you, Tammy. Yeah, no other questions. So it looks like we got through. Thanks again to everyone, and hopefully we'll see everyone next month for the next seminar.